Okay, so to start off the video, we're going to go onto the Supreme Court, specifically the justices of that court, and who better to start off with than the Chief Justice himself, the man, the myth, the legend, John Roberts. So John Roberts grew up in a small Indiana town and actually worked in a steel mill for part of his life. He went on to attend Harvard College and law school and graduated from such, and he went on to serve as a judge on the DC Circuit Court of Appeals until 2005, which then he was nominated to the Supreme Court by George W. Bush.
Later this month, Chief Justice John Roberts will hit the 20th anniversary of his swearing in as Chief Justice.
Nowadays, he leads the Supreme Court in their proceedings and serves as a Chief Justice. One cool fact about John Roberts is that he started off very conservative. However, he has gone more towards the centrist approach nowadays as a means of rationale and to bring about political evenness. Yeah. Now moving down the list by seniority, we have Clarence Thomas. So Clarence Thomas grew up in rural Georgia in deep poverty and credits his strict grandparents for shaping his life into what he is today. Clarence graduated from the College of the Holy Cross as well as Yale Law School and went on to serve as a judge on the DC Circuit Court of Appeals until 1991, where he was elected by George W. Bush to the Supreme Court. Clarence is a very, very conservative justice and is known for his very quiet demeanor in the courtroom. So next up we have Samuel Alito. So Sam I.M. grew up in New Jersey and is the son of two school teachers. He attended and graduated from Princeton University as well as Yale Law School, and then went on to serve as a judge on the Third Circuit Court of Appeals until 2006, where he was nominated by George W. Bush to serve on the Supreme Court. Samuel Alito is a hyper-conservative justice on the Supreme Court and is relatively known for his reserved, serious personality as well as his very detail-heavy opinions. Alright, so next up we have Sonia Sotomayor. So Sonia was raised in New York by Hispanic parents and, just like Sam I.M., attended and graduated from Princeton University as well as Yale Law School. Sonia served as a judge on the Second Circuit Court of Appeals until 2009, where she was nominated by Barack Obama to be a justice on the Supreme Court. Sonia Sotomayor is a liberal judge, and something interesting about her is that she is the very first Latina woman to serve on the Supreme Court, and she was raised in the Bronx. The Bronx. Anyways, so next up we have Elena Kagan. Elena Kagan was born in New York City and went on to attend and graduate Princeton University, Oxford Worcester College, as well as Harvard Law School. Now we have a switch up here. Elena Kagan served as U.S. Solicitor General until 2010, where she was nominated by Barack Obama to serve as a justice on the Supreme Court. Elena is a liberal-leaning justice on the court, and a fun fact about her is that she was the first female dean of the Harvard Law School. So next up we have Neil Gorsuch. Neil grew up in Colorado and graduated from Columbia University, Harvard Law School, as well as Oxford University. Neil served as a judge on the 10th Circuit Court of Appeals until 2017, where he was nominated by our glorious Donald Trump. Neil is a conservative justice, however, he has shown to vote independently from this at times, and a fun fact about him is that he does write books on ethics and judicial philosophy. Alright, so next up we got this guy. His name is stop sign.
Bergie turd kaflurflestink. Bergie turd kaflurflestink. Bergie turd kaflurflestink.
Alright, yeah, so Brett Kavanaugh was born in Washington, D.C., and he was educated at Yale College and Yale Law School, and you guessed it, he served as a judge on the DC Circuit Court of Appeals until 2018, where he was nominated by our King Donald Trump to be a justice on the Supreme Court. Brett Kavanaugh is a conservative justice on the Supreme Court, and he is known for his very eccentric personality.
Sometimes probably had too many beers, and sometimes other people had too many beers.
And next up, we have Amy Coney Barrett. Amy was born in Louisiana and went on to become educated at Rhodes College as well as Notre Dame Law School, and then became a judge on the 7th Circuit Court of Appeals until 2020, where 3 for 3 she was nominated by Donald Trump to become a justice on the Supreme Court. Something interesting about Amy is that she's the only justice on the Supreme Court that did not attend an Ivy League university. Lastly, we have Ketanji Brown Jackson. Ketanji was born in Washington, D.C. and graduated from Harvard Law School. She served as a judge on the D.C. Circuit Court of Appeals until 2022, where she was nominated by Joe Biden to become a justice on the Supreme Court. Ketanji Brown Jackson is a liberal justice on the court, and a fun fact about her is that she's the very first African American woman to serve on the Supreme Court, which is pretty awesome sauce. Next segment, the selection and nomination process. So, under the Appointments Clause, the President has the power to appoint justices to the Supreme Court, which then requires the Senate to confirm the nomination. So, fun fact, there's no formal constitutional qualifications needed in order to be nominated for the Supreme Court, meaning that the President can elect really anybody in principle, meaning that he can choose someone like you, yes you, to be on the court if he didn't know any better. As for this formal confirmation process, the President will first pick a nominee, which then goes to the Senate for approval. It typically gets sent to the Senate Judiciary Committee, which enacts a 3-stage process. Stage 1 involves pre-hearing investigations into the nominee, which involves extensive background checks as well as reviewing previous writings and judicial rulings. Stage 2 starts the public hearing process in the Senate Judiciary Committee, where the nominee and other witnesses testify and answer questions from the Senate. This interrogation-esque process seeks to weed out inconsistencies and flaws in the individual's character and track record.
I have this day an opinion, a personal opinion, on the outcome in Roe versus Wade, and my answer to you is that I do not.
Roe versus Wade is an important precedent of the Supreme Court.
A good judge will consider it as precedent, worthy as treatment of precedent, like any other.
In Stage 3, the committee then votes to make a recommendation to the full Senate, in which they can either vote favorably, unfavorably, or no recommendation. After this, the full Senate will debate on the topic if deemed necessary, and votes whether to confirm or reject the nomination. Once the nominee is confirmed by the Senate, the President then formally appoints the individual to the Supreme Court, and the nominee officially becomes a justice. Now, many times the confirmation process can be long and difficult, which is due to the fact that since there's no fixed qualification requirements for the position, the full weight of the decision often rides on the nominee's backgrounds, writings, past judicial rulings, political ideology, and their public perception. The entire process is inherently political, as justices serve for life and practically shape our fundamental rights and constitutional interpretation. Alright, so now on to case decisions and constitutionality. So the decision-making process of the Supreme Court has several stages, and most cases come to the Supreme Court via appeals from lower courts. It's normally split into 3 sections: state courts, federal courts, and courts of original jurisdiction, and that last one is reserved for cases involving ambassadors and diplomats. The involved parties file a writ of certiorari to request for the Supreme Court to hear the case. Keep in mind that the Supreme Court gets thousands of petitions per term, often around 7,000 to 10,000, with only a small fraction getting accepted for full review with oral arguments, which is around 80 to 100 petitions. Now, the decision on whether or not the court will agree to hear the case is based on the votes of the justices, which involves a custom known as the Rule of 4. This custom states that if at least 4 of the 9 judges vote to grant a hearing, then the court will hear the case. Once this is granted, the court issues an order and places the case on the docket for briefing and oral argument. Okay, so next up we have what is known as the full review procedure. So for the full review procedure, we have the briefing. So once the court agrees to review a case, it goes down a specific path, which involves both parties submitting written briefs that lay out their starting arguments. Most times, the petitioner's brief comes first, followed by the respondent. In some cases, the petitioner gets a reply brief as well. Additionally, amicus curiae briefs may be submitted by third parties who have interest in the case. So after this, we have the oral arguments, and during the oral argument, both sides will get a chance to argue in front of the court. Each party will get around 30 minutes to make their case, of which the petitioner goes first, followed by the respondent. If the petitioner reserves some time for the rebuttal, then they will speak last. In this oral argument, the lawyers from either party will often speak briefly and spend most of their time answering questions from the justices, as they have already read the briefs and want to scope out potential issues and implications of the case. So after the oral arguments, we have the conference. So during this conference, the justices will meet in private in order to discuss the case and vote on it. Normally, the Chief Justice will speak on the matter first, which is then followed by the other judges in order of seniority. This is then followed by a vote to either affirm or reverse the lower court decision. And after the conference, we have the opinion writing. So once the vote is taken, a justice coming from the majority is given the task of writing the court's formal majority opinion. Along with this, other justices may write either concurring or dissenting opinions based on whether they agree with the result using different reasoning or disagree with it entirely. Lastly, we have the enunciation. So once everything comes to a close, the court will publish its opinion and the decision will take effect. The majority opinion will establish the binding ruling under the doctrine of stare decisis, which means that lower courts will have to follow that precedent in future similar cases. So now we'll go into the importance of opinion writing at the Supreme Court level. So opinion writing at this level is quintessentially important to how the court shapes law and constitutional interpretation, as the written opinions dictate how the court explains its reasoning, which isn't just who wins or loses, but also how the ruling applies to the facts of the case, as well as constitutional provisions. It also creates a binding precedent, which influences how lower courts interpret future similar cases, and in order to be in line with the Supreme Court's ruling. And lastly, it records alternate legal reasoning and dissenting perspectives, which through concurring and dissenting opinions have the justices signaling concerns as well as alternate legal theories and potential directions for future challenges or changes. Now, there's 3 different types of opinions in the Supreme Court, which I've been throwing around quite a bit in this video, and those are majority, concurring, and dissenting opinions. So first up, we have the majority opinion of the court. Now this occurs when at least 5 of the 9 justices reach the same decision, and one of the justices of the majority writes the majority opinion. So this explains the court's decision and reasoning, and this is important as this is the binding opinion and the law going forward. All lower courts must follow it under stare decisis, and if they don't, they die. Now, in tandem with the majority opinion, we have the concurring opinion. Now, this is written by a justice of the Supreme Court who does agree with the outcome of the majority, but wants to express some kind of different legal reasoning or highlight different issues of the case. Now, this isn't really as binding in the same way as the majority opinion, but it can absolutely influence future cases as well as shape certain legal debates, and it can also suggest certain alternative legal routes to this certain issue. Now, on the flip side of the concurring opinion, we have the dissenting opinion. Now, the dissenting opinion is written by a judge who disagrees with the majority's decision and reasoning. Now, this isn't really binding and it doesn't have an immediate effect, but dissents can absolutely be influential over time, as they do preserve alternative legal reasoning and draw attention to what the dissenting judges believe the court got wrong. And these dissenting opinions can be cited in future cases or legislative debates in hopes of pointing out what these courts got wrong over time. Now, to understand why this matters for constitutional law, we have to understand that these kinds of constitutional questions often involve principles that can be applied broadly, such as free speech, equality, separation of powers, federal versus state authority, etc. And the way that the court writes its opinions can honestly reshape how the Constitution is understood going forward, which will quite literally affect millions of people for future generations. Now we'll be looking at an upcoming Supreme Court case, and we'll be predicting how each of the 9 justices will rule on the case. So we're going to be looking at Cox Communications versus Sony Music Entertainment. So the facts of the case is that Cox Communications Inc. is a major internet service provider selling internet, telephone, and cable television to millions across the United States. Between 2013 and 2014, some of Cox's internet subscribers used peer-to-peer file-sharing networks such as BitTorrent to download and distribute copyrighted songs owned by numerous record companies and music publishers, including Sony Music Entertainment, or the plaintiffs. These record companies, through the Recording Industry Association of America, or RIAA, hired a company called Mark Monitor to monitor illegal file sharing and notify internet service providers when infringement was detected. Mark Monitor sent Cox over 163,000 notices of infringement during the relevant period. In response, Cox operated a 13-strike policy under which it warned or temporarily suspended subscribers after repeated notices. But in practice, it rarely terminated service for copyright infringement, while regularly terminating service for non-payment. Plaintiffs became frustrated with Cox's limited enforcement against repeat infringers and sued Cox instead of his subscribers, alleging that Cox was secondarily liable for copyright infringement occurring on its network. Specifically, plaintiffs contended Cox either intentionally contributed to or benefited from its subscribers' infringements by failing to take adequate steps to stop it, thereby inducing or materially distributing to the unlawful acts. The U.S. District Court for the Eastern District of Virginia denied Cox statutory safe harbor under the Digital Millennium Copyright Act, or DMCA, and allowed the case to proceed to trial on theories of vicarious and contributory copyright infringement. The jury found Cox liable on both counts and awarded $1 billion to statutory damages. On appeal, the U.S. Court of Appeals for the Fourth Circuit affirmed the jury's finding a willful contributory infringement, reversed the vicarious liability verdict, and vacated the damages award, remanding the case for a new trial on damages. So the question here is, can an internet service provider be held liable and found to have acted willfully for copyright infringement just because it knew users were infringing and did not terminate their access? Given all this, here are my predictions for this upcoming court case. For Chief Justice John Roberts, my prediction is a no. My reasoning being that, from what I've seen, Robert prefers narrow, pragmatic rulings that avoid big disruptions. He may try to limit liability so ISPs aren't forced to become aggressive internet police, but that is unlikely. Clarence Thomas, my prediction is a no. My reasoning being is that Thomas generally favors protecting property rights, but also resists expanding vague, broad liabilities that would disrupt major industries. He's likely to avoid a rule that would force ISPs to cut users off based solely on a notice. Samuel Alito, my prediction is a no. My reasoning being is that Alito typically worries about broad rules that create large economic or practical consequences. He likely sided with protecting ISPs from sweeping secondary liability exposure, similar to Clarence Thomas. Sonia Sotomayor, my prediction is a yes. My reasoning being is that Sotomayor has shown clear concern for enforcing rights when there's evidence of obvious and repeated wrongdoings. I believe that she would be sympathetic to creators when there's strong evidence that an ISP ignored repeating notices of piracy. Glenna Kagan, my prediction is yes. Why? It's because Kagan has a track record of defending robust copyright protections in past cases and is likely to favor holding a company accountable when the record shows that it got thousands of notices and didn't meaningfully stop the perpetrators. Neil Gorsuch, my prediction is a no. My reasoning being is that Gorsuch has a skeptical approach to expansive liability doctrines, so I believe that would make him likely to resist extending these liability doctrines onto passive service providers. Brett Kavanaugh, my prediction is a no. My reasoning being is that Kavanaugh often balances business and tech concerns with enforcement of the law, but he may worry about forcing ISPs to over-police networks, so I believe he would vote no in fear of strong-arming such a large industry. Me, Coney Barrett. My prediction is a no. The reasoning why is that I believe Barrett would lean away from creating expansions of liability based on loose definitions and would instead vote to protect ISBs from aggressive doctrines like this. Ketanji Brown Jackson, my prediction is a yes. The reasoning why is that Jackson shows a clear concern for fairness and pragmatism. Once given clear evidence of repeated notices and very little enforcement from Cox, then I believe she's likely to support expanding liability such as this in areas where companies like this are not meeting the code. So overall, my prediction for this upcoming case would be a resounding and majority no from the court, which is due in part to the wording from Sony making it appear as such that ISP providers will have to become unwilling enforcers due to a very broad and inconclusive liability enforcement. However, I do see a possibility of a close yes if they clean up this wording.